A Guide for Immigrants Accused of Crimes in Florida. Written by Joseph Mitkevichus. Which crimes can get you deported? Understanding immigration consequences by charge type. Not all criminal charges have the same effect on immigration status. Here we explain some common categories of offenses and how they typically impact immigrants. This section can help you understand what to ask your lawyer about your specific charge. Keep in mind, immigration law is complex and there are exceptions, but we will cover the basics. Crimes of moral turpitude, CIMT. A crime of moral turpitude is a term in immigration law for a crime that involves dishonest or very bad behavior, showing a lack of moral character. There's no single list in the law, but generally theft, fraud, and many crimes involving an intent to harm someone or deceit are considered CIMTs. Examples: shoplifting, robbery, credit card fraud, writing bad checks, burglary, etc. Some assault offenses can be CIMTs, if they were very serious or had an element of evil intent. Minor offenses like simple driving without a license or disorderly conduct usually are not CIMTs. Why it matters. If you are convicted of one CIMT that occurred within 5 years of your admission to the U.S., or within 5 years of getting a green card, and the crime is punishable by a year or more in prison, you are deportable. Also, if you ever have 2 CIMT convictions, no matter when committed, you are deportable. Even a single CIMT can block a non-citizen from being allowed into the U.S. or from getting a visa green card, they call it inadmissible. Advice: if you're charged with any kind of theft or fraud or other CIMT, ask your lawyer if there's a way to avoid a CIMT conviction. Sometimes a plea to a different charge, like trespass or receiving stolen property or something not involving dishonesty, can be the difference between deportable and not. Also, first offense petty theft has a special exception in immigration called the petty offense exception. If the sentence was less than 6 months, it can avoid inadmissibility. But don't rely on that without legal guidance. Best is to not have a CIMT at all on your record. Aggravated felonies. Aggravated felony is a term in immigration law that covers a list of many crimes. Despite the name, it's not only felonies and not always aggravated in the normal sense. Some examples: murder, rape, drug trafficking, firearms trafficking, fraud or tax evasion with loss over $10,000, theft or burglary with a sentence of a year or more, crimes of violence with a sentence of a year or more, child pornography, smuggling immigrants, etc. It's a long list in the INA section 101A43. Why it matters. If you are convicted of an aggravated felony, deportation is almost certain. You become ineligible for most forms of relief. You usually cannot even ask an immigration judge to let you stay except in very narrow cases. Aggravated felons also can be barred from ever coming back to the U.S. in the future, even on a visa. If you have a green card, you'll almost surely lose it. Also, aggravated felonies often trigger mandatory detention, meaning if ICE catches you, you cannot be released on bond while your case is pending. You must stay locked up until you're deported. It's very severe. Advice: avoiding aggravated felonies is top priority if you want any chance to stay in the U.S. If a plea deal would turn your offense into an aggravated felony, you might need to fight for a different outcome. For example, reduce the sentence to 364 days, or change the charge. Sometimes just that one day less makes a life-changing difference. Always ask your lawyer if the proposed plea could be considered an aggravated felony. If they're not sure, push for a safer route. Remember, even some misdemeanors can become aggravated felonies in immigration. It depends on the sentence length and the nature of the crime. Drug-related crimes. Drug crimes are one of the most common triggers for deportation. U.S. immigration law is very harsh on any controlled substance violation. This includes offenses like drug possession, sale, manufacturing, trafficking, or paraphernalia possession. The only tiny exception is one single offense of possessing a small amount of marijuana, typically under 30 grams. That might not make you deportable. But anything else drug-related, even just possession of a small amount of cocaine or meth, or a prescription drug without a prescription, can lead to deportation proceedings. If you're undocumented or on a visa, any drug conviction, besides the tiny marijuana exception, can make you inadmissible, meaning you can't get legal status until maybe you get a waiver after many years, and deportable. ICE loves to go after drug cases. Even if it's a minor charge, once you're convicted, ICE can detain you. If you're a green card holder, a single drug conviction, again other than a very small marijuana case, makes you deportable. You could be placed in removal proceedings and likely lose your green card. There are almost no defenses against a drug deportation except sometimes if it was just marijuana, or if you can successfully complete a drug treatment diversion that doesn't count as a conviction. Drug trafficking charges, selling, intent to sell distribution. These are usually treated as aggravated felonies if convicted. That's worst case because you'd be deported and never allowed back. Florida has some tough drug laws, and even prescription pill sharing or having a large amount, which implies intent to sell, can be felonies. Advice: if you were charged with a drug crime, explore diversion programs. Many Florida jurisdictions have drug court or diversion for first-time simple possession. Often these require a guilty plea up front, danger, or an admission. But some diversion programs may not, or if they do, the key is whether that counts as a conviction. It's complicated, so have your lawyer find out exactly how the program works. If the program does not require a guilty plea or finding of guilt, taking it is great. You do treatment, case gets dismissed, and you avoid a conviction. Immigration-wise, that's good. If the program does require a plea that's held in abeyance, that's risky, because immigration might see it as a conviction anyway. Another strategy is to see if the charge can be amended to something non-drug. Sometimes, a sympathetic prosecutor might allow a plea to possession of drug paraphernalia or disorderly conduct instead of drug possession. That could be slightly better. Paraphernalia is still a controlled substance offense in immigration's eyes, unfortunately, if it relates to a drug. It's tough. The best outcome is avoid any drug conviction entirely. If evidence is weak, fight it. If it's strong, push for rehab or plea to a very minor charge if possible. And absolutely avoid any suggestion of distribution to trafficking. Do not plead to intent to sell if there's an option to plead to simple possession, for example, because the former is an aggravated felony. The latter is at least not an ag felon, but still deportable. Domestic violence and assault. Crimes categorized under domestic violence are particularly dangerous for non-citizens. U.S. law specifically states a conviction for a crime of domestic violence, which means violence committed by someone against a spouse, ex-spouse, partner, child, etc., makes a non-citizen deportable. This includes not just actual hitting, but also things like stalking or violating a protective order related to domestic issues. Assault battery. In Florida, a simple battery hitting someone could be a misdemeanor. If it's against your spouse or someone you live with, it's domestic. A conviction of domestic battery can get you deported even if it's first offense. If the charge is aggravated battery or assault with a weapon or serious injury, that's even more serious, felony, definitely deportable, possibly an aggravated felony of serious harm. Stalking or restraining order violations. These also count for the domestic violence deportation ground if the victim is someone you have a domestic relationship with. Child abuse. Any conviction for child abuse, child neglect, or child abandonment is a deportable offense too. Even if it's not labeled as domestic violence, there's a separate line for child abuse in immigration law. Advice: domestic-related charges are often very emotional and can be complicated. Sometimes the stories are he said, she said. From an immigration perspective, avoiding a conviction under a domestic violence statute is crucial. If you had a dispute with a family member and the police charged you, talk to your lawyer about options like anger management courses or other ways to resolve it. Sometimes, if the victim doesn't want to press charges, a lawyer can get a case dismissed or reduced. If not, maybe a plea to a different charge like disorderly conduct or simple assault, without the domestic relations specified, might avoid the specific deportation trigger, though it could still be a CIMT if serious injury involved. Every detail matters. Even the relationship to the victim matters. If you are not actually legally married and not living together, maybe it's not domestic in definition. Your lawyer can see if it can be treated as a non-domestic fight. Also, if you're offered a probation, know that a conviction is a conviction. Probation doesn't save you. Better to have the charge dropped entirely via some intervention program if possible. Important. Many immigrants feel they have no defense if the victim is accusing them, but you do have rights. If you are innocent or the incident is exaggerated, fight it with your lawyer. A wrongful domestic violence conviction is a tragedy for anyone, but for an immigrant it means losing your life here. On the flip side, if you really did it, consider trying to negotiate something that, while holding you accountable, doesn't put the domestic violence label on the conviction. This might be hard, but creative lawyering has, for example, gotten charges amended to battery without mention of domestic or some lesser offense. Firearms offenses. Firearms, guns, and other weapons charges can also affect immigration. Federal immigration law lists firearms offenses as deportable. This generally covers any conviction for buying, selling, possessing, or using a firearm or destructive device in violation of law. For instance, if you are convicted under Florida law for carrying a concealed firearm without a permit, or being a felon in possession of a firearm, or discharging a firearm illegally, those are deportable offenses for non-citizens. Note: the law doesn't count simple weapon possession of a knife or something, but firearms and explosive devices are specifically mentioned. Advice: if your charge involves a gun, definitely be aware of this. Sometimes, again, lawyers can negotiate charges. Perhaps a prosecutor might drop a gun charge in exchange for plea on another charge. If you have no status, any gun conviction will also make it nearly impossible to get legal status later because it's a serious red flag. Best to avoid the conviction if at all possible, through diversion or reduction. If the evidence is strong, e.g., police found an illegal gun on you, your lawyer could focus on minimizing the sentence and see if immigration consequences can be mitigated later. Though deportable, you might seek a form of relief if eligible. Other offenses. There are other categories, less common, that cause problems, such as prostitution-related offenses, human smuggling, espionage, national security stuff, etc. But those are rarer for most people. One thing to mention: driving under the influence, DUI. A standard first-time DUI is typically not an offense that makes someone deportable by itself. It's not a CIMT because it's negligent, and not an aggravated felony unless someone was hurt badly. However, ICE has targeted DUI offenders in the past as a priority. And if there are aggravating factors, like DUI with injury or repeat DUIs, it can harm your chance at discretionary relief or DACA status, etc. So while a single DUI conviction might not directly trigger the deportation statutes, it still can cause issues. For example, a DUI can bar you from deferred action for childhood arrivals, or make a bad impression if you ever seek an immigration benefit requiring good moral character. So don't take DUIs lightly either. Always verify the exact immigration consequence with a knowledgeable person. Use this knowledge to discuss with your lawyer which charges to fight hardest against and where a plea might be safer.